Hi there, my name is Calibos, the only boss with one S. Happy New Month to all of you. Welcome to a month of new possibilities. Do you know why life has been made so easy? It's because of TapTapSend. People, TapTapSend is here to make your life easy if you want to transfer money to Ghana. If you want to transfer from USA, if you want to transfer from UK, Europe, Canada, a lot of places all to Ghana. And guess what? When it comes to Ghana, there's no e-levy charge. So, what are you waiting for? Download TapTapSend on Google Play Store and App Store and be ready for exciting offers coming your way each time, every time on TapTapSend.
TapTapSend. Send more, spend less.
Living in Ghana, abroad, a first-timer visiting Ghana, or a company wondering where to get quality service providers in Ghana for any job? Then Ejumapa On Demand Services is here to assist you. Ejumapa On Demand Services connect requesters and service providers such as masons, plumbers, electricians, auto repairers, home and office cleaners, trash collectors, rent agents, spa attendants, roofers, beauticians, teachers, CCTV installers, and all artisans on one platform. Yes, one platform. Trust Ejumapa On Demand Services to sort you out any day, anywhere, and at any time. To download the app, please visit the App Store and Play Store or visit our website www.ejumapa.com.
Hey, Debusia for Mama about SBTV Africa, so the voice of the community. And then Friday, thank God it's Friday. It's Yamunya SBTV Africa fans, new ones, any old members in one family. Me damasi say. They be animal SBTV Africa mo supported brand no more mo share mo like it mo subscribe na no nyame share mo and mo subscribe here so dey mo try na mo subscribe say ne be ya the videos ne bebre ba videos dey do so pa na next Friday there onim say Friday be at 5:30 me lawyer wisdom akao wise smart solicitors omo UK London they be Friday be no important topics mo UK mo pese mo ko UK na topic o dey ba mo Schengen visa ni Schengen den mo Schengen passport mo pese mo ko UK ni ade ni nyina important nti Schengen for so na mo mrem na mo metie topic o dey ba because our topic na I'll say can EU nationals still bring their family members to the UK into the EU the tie no na tie fill out the bro ni ade share link no men hwenkwa share mo bi WhatsApp so Facebook link no share mo bi na mo form adwen kire bra bo 6 na 6:15 na e be bisa questions o question bi obeso bisa no ma me go straight time ko me ne lawyer wisdom akao wise man solicitors efo
DJ
F1 where's all
F1
me nkejo
Luciano le LTP Luciano
akpe na miesia
akpena maru
lawyer wisdom akao champion man wise man solicitors na mene lawyer before be we mene me who be busy see our TikTok na so guy no asem no kind of man mene guy be a interview na obi twa to TikTok na guy be comment say oh na DJ nyame you interview then guy ne ka be so we try no can about connection man be o dupe no Ghana some time ago na guy ne kind am say eh na da be na SBTV Africa be starting interview connection people me interview connection men TV besides our show SBTV Africa no move wala sisi and check be less than 10 minutes now so by anyway lawyer akwa by na dey na bre
yo DJ me da say tie phone so yemamo obia akwaba DJ I mean very interesting developments in the updates and then they are share and that topic no as to whether EU4 still no although UK APU no EU4 bet me assign the omoba aba omoma penyimfo any mo friend na ana omoyiri ebe that UK ha na so yes That is what we want to look at. But before I ever call this one up, say asylum. A bit me by UK ha na omabeseke asylum. Because omo jani efi ho ewo Ghana ana omo krom na omo jani fe ho na omo ba UK. Now there are 5 major grounds upon which Obi Betime abeseke asylum in the UK. A be either political persecution, religious persecution, cultural reasons, sexual orientation, and our sexuality. And it means here any other thing that will endanger your life in the country in which you are. Now, where Johnny if you have a UK has a secure asylum. It means some practices. Example, the female genital mutilation. Na a man circumcision no. That was a very strong ground. Na ebinimu ejinasu ediseke asylum. Here practices like trococy some years ago, but thankfully some of those things have subsided to the extent that you hardly hear of those things anymore in Ghana particularly. And my main kind of say it's been driven underground. So based on some of these things, Ebinimu Timiba, you cannot become to seek asylum. The politicians, religious reasons, etc. etc. And I am a program recently na government no episode omodi asylum seekers ewo UK no edi ko Rwanda na omo akwa process omo asylum application wo ho ansana so qualifier omodi waba back to the UK. Now the first flight was scheduled to have left some time ago, but the case ni court organizations be institutions be some charities case ni court anti pleno anti miento and the home office for also a challenge case no to a higher court and still anye and finally, well, maybe at this point I can say finally, but it may be subjected to further challenges. Last week court no any decision about the Court of Appeal said UK government entimi mfa obia enko Rwanda. Nienti a omusi omuntimi mfa omunko ni say two judges NMR the majority decisions. Master of the role said Geoffrey Vos and Vice President of the Court of Appeal Civil Division Lord Justice Underhill. Omumienu na omuma the majority decision. The Chief Justice Lord Barnett although he dissented and would have dismissed that particular ground of appeal if he had made a decision. But I don't know, he dissented into one country and found. In other words, he decided not to take any side. But Justice Master of the Role said Geoffrey Vos and Vice President of the Court of Appeal Civil Division majority country. Rwanda is not a safe country. UK, Betumidi will be alcohol for asylum purposes to go and process the application. Sinyomu Kanisa, they base their decision on 4 or 5 points. The first one is that there is the evidence of the way in which asylum interviews are conducted in Rwanda cannot be relied on. UK Hano, so Biba Secure Asylum, they process the case, you do the initial interview before you go for the main processing, before they determine set ampa yedibemo anamiem fama. And the judge Nika said, Rwanda Hono, the evidence of the way in which asylum interviews are conducted in Rwanda cannot be relied on. In other words, Rwanda any country more experience in dealing with asylum cases. And ọmụ mfa obi mfi UK ha ɛmfa ne nkɔ Rwanda ɛnkɔ nkɔyɛ guinea pig ama judges no another course no to do try and error to see whether this person qualifies for asylum or not. And here, number one reason and unti and almost say UK and to me fa ubia enko Rwanda and to me fa asylum seeker bia enko Rwanda. Number two reason is that the absence of opportunity for claimants to present their claims through a lawyer. In this country, so who claim asylum, you have the opportunity to use a lawyer to represent you, to argue your case for you in court. Sometimes, so who call for asylum interview now, another screening now, but me, I'm a lawyer, got name. Although lawyer no enkasa no, but me, I'm not got name. Na what to me, etienia, ekoso. Now, of course, but to me, I notes in future, say, I'm gonna refuse you, lawyer appeal interview no more no when na mo kan and tasum and no aye grounds obeteme in Rwanda the absence of opportunity for claimants to present their claims through a lawyer is very, very minimal, or possibly it is totally absent. Enunti judges ni say opportunity ni ho or Rwanda ama obi a or claim asylum but me using lawyer e dey argue the case no say ni ho sa endie enya ade a on better so say UK and obi MF UK ha the government should take anybody from here to Rwanda. And that was a good point. That's point number 2. Point number 3, and until a judges ni say Emma Obi and Emma government name for Obi or seek asylum and call Rwanda ni say evidence that the authority charged with determining asylum claims does not have sufficient skills and experience to make reliable decisions. In other words, institutions now and authorities now UK government added to me Asha Munsa ewa Rwanda hono. UK judges say they are not sure whether they have enough skills, if they are experienced enough to conduct the business of deciding whether a person is eligible for asylum or not. So the evidence that the authorities charged with determining asylum claim does not have sufficient skills and experience to make reliable decisions is one ground on which the UK judges, the Court of Appeal judges are saying the UK government cannot remove any asylum seeker to Rwanda because there is not enough or there are not enough evidences to prove that the judges, the system, the authorities have the skills enough to deal with asylum cases in Rwanda. Anunti Court of Appeal judges ni say Obia Enfi Krumha Enko Rwanda until some changes are made. The next one, point number 4, I will say the evidence that non-governmental organizations, NGOs, said to be able to provide legal assistance are unlikely to have sufficient capacity to do so. Nyamuchani said, now, UK government say the Obiko Rwanda, so Obi Osiki Asami didn't call Rwanda, but to me, and NGOs were said lawyers ni hompua, NGOs were non-governmental organizations say on bet me support Nipano through the asylum process. And I judge is say David. Nyamu Canadian Towson. NGOs ni krano. How many NGOs never Rwanda ho? Capacity ben no omuwo. Nipa sang and engagement with these NGOs. What is their experience? Now, Saudi Nkrofone, if you take 5,000 asylum seekers, 7,000, 8,000 asylum seekers, NGOs now, area they have 10 or 15 NGOs. They may not have the capacity to deal with these asylum cases. And nonte, ma UK government, and phobia, and call Rwanda, set or call Aqua Processum or Ansana Omodioma back to the UK. Because of that, the Court of Appeal says nobody should be taken to Rwanda for processing under asylum claims until and unless some changes are made. Point number 5. As is the fact that the appeal process to the Rwanda High Court is wholly untested, coupled with grounds for concern about whether the Rwanda judicial culture means judges are reluctant to reverse decisions of the executive decision makers. 2 points. Number 1, the appeal process in Rwanda to the High Court, they don't know. It's not tested. They don't know. In the ABI or the court of Koseki Asylum, you do a court, process you, almost you don't qualify for asylum. And don't say, as I said, you go chrome. Nipanonsu, or good case, based on a nunti, and Kasasa the court. The point is, say, at me call the first tier tribunal or the first court numpo, not a Nipan or Luzu or what is the chance or what is the possibility that they can go to another higher court until they get to maybe the highest court of the land? There is no evidence that the appeal process in Rwanda is able to handle these cases, or even if they can appeal to the higher courts until it gets to the Court of Appeals in Rwanda. In other words, ABI, Sanipano Echo Court, na yamfa manu first court hora, yabeka se ultimate court to maybe a further appeal. You can't go to a further appeal and don't see naturally say that is the end of the case. Because of that, the Court of Appeal in the UK says until and unless there is evidence that the court in Rwanda, the process of the appeal in Rwanda to the High Court is assured, or they can be assured, nobody is going to leave the UK to Rwanda as an asylum seeker. The system is wholly untested. The Rwanda system is wholly untested. UK Hano, se usiki asylum, the first point of call is the first tier tribunal. So called first tier tribunal, you can appeal to the first tier tribunal for permission to appeal to the upper tribunal. So first tier tribunal numpo permission now. You can still apply for permission to the upper tribunal to appeal to the upper tribunal. So you can still appeal, you can seek permission to appeal to the Court of Appeal. So you have the system to appeal all the way to the Court of Appeal. That is in the UK until your case is decided and it comes to the point where you know that at least if you have won, you have deserved justice. If you haven't won, also, or if you don't win, you still know that you went through the due process of the courts to the extent that you know that you've done everything you should do. In Rwanda, the court system is not tested, it's wholly untested. And because of that, the judges in the Court of Appeal in the UK are not comfortable sending people to Rwanda to be used as guinea pigs. And almost say nobody is going to be sent to Rwanda. Nobody who is seeking asylum is going to be sent to Rwanda. The second point they made within the point number 5 is that it is also possible that if the executive in Rwanda make a decision, the courts may be afraid or they may not be bold enough to change those decisions. In this country, if the executive, the prime minister, the lawmakers, the the legislature, parliament, if they make any law and it is not in accordance with human rights, etc., the courts have the power to change those decisions. In this country, the law works. In the United Kingdom, the law works. So the judges are not afraid to change decisions of the executive. In Rwanda, the Court of Appeal in the UK says they do not know if the judges are strong and bold enough to implement the law, regardless of what decision the executive make. Maybe the executive is more powerful than the courts in Rwanda. And notice obi ko edu udi obi ko ho sa osiki asylum na pa mano na say the executive makes a decision or they go to parliament and make a decision that all asylum seekers should be returned to their country. In that case, the judges in Rwanda may not be strong enough to challenge the decision of the executive. And because of that, the UK courts, the High Court, the Court of Appeal says nobody is going to be removed from the UK who is seeking asylum to be taken to Rwanda to be processed before they are either determined for them to come to the UK or they should go back to their country. And they gave some examples. There are countries like Syria, countries like Afghanistan. Some of those countries, the fear is that people from those countries who are in the UK seeking asylum, who may be returned to their country from Rwanda, they may be subjected to inhumane treatment or torture. They may be subjected to prosecution. They may be subjected to prosecution or inhumane treatment. Persecution or inhumane treatment, especially people from Syria, people from Afghanistan, and those other countries that came to seek asylum in the UK. And because of this, the judges have decided that nobody is going to Rwanda until and unless there are changes in the system and they have the assurance that none of the 5 points listed above is going to take place. Rwanda is not a safe country. Rwanda is not a safe country for processing asylum grounds in Rwanda before they determine whether they should bring them to the UK or not. So DJ, this is very excellent decision by the Court of Appeal. So nobody is going to be removed from the UK. Nobody who is seeking asylum, let me be emphatic, nobody who is seeking asylum in the UK is going to be removed to Rwanda because of the 5 points that the judges have based their decision on. So, good news, if you are seeking asylum, progress with your asylum seeking, and we believe that these points they have mentioned, I doubt if anything will change anytime soon. So, DJ, that is the updates I want us all to be fully aware of before we progress to the next stage. Right. I think DJ Nyamio.
Yeah, lawyer, continue. Why?
Mate. All right. So that is a good news. The other day, I put out some information with regards to the raids UK is conducting, immigration raids in different places. Because of election, but next year we are going to have a general election. The government wants to prove that they are doing something serious about immigration, and until they have started making raids. They've started going to places where people gather. We talked about the barber shops, the saloons, the clothing shops, the car wash bases. These are places that they usually go to see if people who are there have their documentations or not. So I advise that if you are not okay, I am not saying don't associate, but just be mindful of your surroundings so that in the event that anything happens, you don't end up getting into trouble with the immigration or with the police. So that is very, very important update I want to remind everybody of. Another very important thing I want to remind us of, which I will keep saying until there is a change, is that I said it last week. Certificates, the government or the Home Office has begun to go back on people's certificates. Certificates that were used in applications, they are going back to check if some of those certificates are legitimate, if it is genuine documents that were provided. I have had a few calls where it came to light that the certificates were not legit. I don't see it's created a lot of problems for the individuals. May I ask that if you want to apply to come to the UK, please use the right documentation, certificates, and I am sure the application, if it is successful, you have your peace of mind in the UK without having to be in trouble with the government when you get here. Um, yeah, so that is that. That is that. So then the other thing is the marriage certificate. I've talked about it a lot of times, so I don't want to go back into that as well. The certificate should be done properly, and then I am sure if everything falls in place, you will be able to come to the UK without having any difficulties. Now, my main topic for today, the topic I really want to talk about today, I'll keep it very short and sweet. Then, if there are any questions, I can respond to them. And if there are not any questions regarding this particular topic, but there are other questions, I am more than happy to respond to them. What I want to talk about is, can EU nationals bring their family members to the UK? Now, in 2006, we had the Immigration EEA Regulations 2006. And then as the years progressed, after 10 years, it changed to Immigration EEA Regulations 2016. So those were the rules that were governing EU nationals and their family members in making application to come to the UK. And it was pretty smooth. Under that regime, we had two types of family ties. We had the direct family ties, and we also had the extended family ties. We had the direct and we had the extended family ties. Direct family ties and extended family ties. Now, I think we all know that the UK, we had a referendum and the UK decided to leave the EU. Recently, I read an article by a very staunch UK MP, a strong conservative MP, who said leaving the EU was a mistake and it is hurting them. Therefore, they should consider going back. They should consider going back. But I doubt if they ever will, or maybe they may want to use the Norwegian system in making their joining the trade, the free trade market. Now, that is not the issue we are talking about. What we are talking about today is, can EU nationals still bring their family members to the UK? The answer is yes, but it depends, or it depends on which family type you're talking about. Before the 31st of December 2020, when the UK left the EU, what happened was we had two ties of family. We had the direct family and the extended family. The direct family was made up of family members in the ascending order and family members in the descending order. The people you came from and the people who come out from you. Ascending order: your great grandmother, your great grandfather, your grandfather, your grandmother, your mother, your father. You came from these people. So they are all family members. You came through these people, so they remain family members in the ascending order or in the higher order. And then we also had family members in the descending order. That is, people who come out from you or people who came out from you. In the ascending is father, mother, grandparents, etc., etc. Descending is down, children, grandchildren, great grandchildren. That is in the descending order. So, in that case, you could bring your father, your mother, your grandparents. You could still bring them, and you can bring your children, your children's children. All are family members. That was before the Brexit. After Brexit, you can still bring your father, your mother, your grandparents, and your children, your children's children. You can still bring them to the UK. I just had a decision, 3 grandkids, application successful, granted, and they'll be coming to join their grandmother next month. Next month. She was so happy, so pleased that her grandkids are coming to join her because she is the EU national and her grandkids are coming to join her. We just got a decision last week and they went for their passports with the endorsement in it last week. She took pictures and sent to me. It means that if you are an EU national, you can still bring your child or your grandchildren easy to the UK. After Brexit 2020, 31st December, the UK cut off all extended family members. Now, what we mean extended family members, we mean your uncles, aunties, brothers, sisters, nephews, nieces, granduncles, grandnephews, grandnieces. All these people have been cut off. They can no longer come to the UK. Let me say it again. Uncles, aunties, brothers, sisters, nephews, nieces have all been removed from the EU provision. You cannot bring them to the UK anymore because the UK is no longer part of the EU. So from the 31st of December 2020, EU nationals cannot bring their extended family members. You can still bring your family members, like I said, father, mother, children, grandchildren. You can still bring them to the UK, but not extended family members. Now, let's go to which categories and what you need. Family members. Now, we are not focusing on family members only. Family members, we have 2 categories. Like I said, the ascending order and the descending order. Now, if they are your children, we also have 2 categories. So, 2 categories and another 2 categories under the children. The children, we have dependent children and non-dependent children. So, if you have a child and your child is more than 21 years old, that child, you have to show they are dependent on you. If they are more than 21 years old, you have to prove 2 things. The first thing you have to prove is relationship. Relationship. You have to prove that the child is related to you. In other words, you have to provide evidence such as birth certificates or DNA to prove that they are your child. If they are more than 21 years old, you need to prove relationship. Then you also need to prove dependency. Let me say it again. If your child is more than 21 years, you need to prove two things. The first one is relationship, the second one is dependency. You have to prove this. Relationship is usually not a problem because a DNA, you can do it, or the birth certificate, you can use that to show. Or you can even use the weighing card of the child to show the relationship. Weighing card, birth certificate, DNA. These three things can come together to prove the relationship between you and your child. So that is not a problem. Where the problem is the dependency. We are already more than 21 years old. A person who is more than 21 years old, how can you prove that they are dependent on you? It is not unusual, especially in our countries, Ghana and other countries. It is not unusual that a child that is more than sometimes people are 35 years and they still depend on their parents because they don't have work to do. So if you have a child that is more than 21 years, you have to show that they are dependent on you. How do you prove this? Number one, if they are living in your house, you have to provide the documents proving that the house is your home. So that is one. You have to use that to prove it. That is your house documents. Number two, if you pay the utility bills, gas, water, electricity of the house, you have to provide the evidence that you are the person responsible for payment of all these bills. You have to provide proof that you pay all this. That is evidence of them depending on you to pay those expenses on their behalf because they're not working. So you are responsible for everything that concerns them. The other thing is that if the house is not your house, but you rented the property for them, then it's advised that you provide the tenancy agreement in your name. You rented the property for them, and they are living in that address. So the property, the tenancy agreement is in your name, and therefore that is sufficient evidence to show that you have rented and they are living there, and you are responsible for paying the rent on their behalf. Sometimes the landlords, if the bill comes, if electricity bill comes or water bill comes, they just know the amount and then they share it for all the members of the household and everybody pays their bit. So you may not have receipts to prove that this is how much I paid or not. In Ghana, we don't have a lot of receipts for a lot of things. We don't have receipts for a lot of things. So you need to prove your case and prove it very well. So we are saying tenancy agreement or your house documents to show that the property is yours and evidence that you paid the bill on their behalf. The next one is if you have door to door, if you do door to door or shipping on their behalf, you can do that. You provide the door to door evidence to prove that you send them items from the UK. So maybe Christmas, Easter, and other occasions, you send them items for their welfare. Maybe shoes, sardines, rice, oil, detergents, and things of the sort. You ship it to them, and it is in their name. So the shipping invoice is in their name. And because of that, you can also again prove that you are responsible for their welfare. That is also another proof. I've talked about property, your own property, tenancy agreement if it is rented, shipping, door-to-door shipping on their behalf. You provide the invoices to show that you are the one who look after them, and this is the evidence which shows that you are responsible for them. So that is what it is. Then another thing is money transfer receipts. If you send them money, you have to prove with the money transfer receipts. Receipts that you sent to them and receipt that they received the money. Two ways. What you sent to them and what they received. You have to provide these receipts to support your application. Very, very important. And also, if they do, and of course, before I go to the next one, if the receipts go as far back as 10 years, 15 years, if you can, please provide all those receipts to support your application. The further far back it is, the better your case is. The further back it is, the better the argument that you are responsible for them. Not just 6 months and not 8 months. What happened to the years before? And the idea, so when I will show them from Holland and Sana Ubaha. So bet to me, I should share the receipts, those receipts from Holland, or contact the money transfer agency in Holland or Germany or Portugal or Spain. They can give you that, and now the account that shows that you are the one responsible for the children's upkeep or your adult child's upkeep. You need all of that. Then you also need to prove how they use their money. Maybe if it is for medical needs, if they go to the hospital, private hospital, they have to pay. If you can provide evidence that yes, this is the receipt. When they went for treatment, this is the receipt that they were issued, you can use that as a supporting evidence. If they were going to school and the receipts are issued not in your name but in their name, you can also prove that the monies that I send to my children or to my child is what they use to pay for their tuition fee, they used to pay for the accommodation, they used to pay for the medical needs, etc., etc., etc. Of course, transportation. In Ghana, we do not give receipts usually in Trotro. Nobody takes receipts in Trotro. And that is the most common form of transport system in Ghana. Obia Emma receipt or Trotro. So when you make an application, now Obroni Ebisa say, what is the receipt to show that your transport, the transport you take, etc., etc., provide receipt. If it is refused, take it to court and challenge them and tell them Ghana, nobody provides receipt for using Trotro. Even Bolt and Uber, you may even see it on account, fine. But when it comes to Trotro, nobody gives receipt. When you go to Makola to buy food, when you go to KJTR market to buy food, no market woman gives receipt. So if the application is refused because you have not provided receipts to show how you spend the money, take it to court and challenge them. If you have a judge who is open-minded and see that the way things are in the UK is not the same as it is in other countries, you will win your appeal if you are consistent with your evidence and you give evidence, or your statement is consistent and you give evidence in chief which is consistent with the evidence on the documentary evidence you have. You should be successful in your appeal. So let me say that when the child is above 21 years, or if the child is above 21 years, the application will most certainly, about 99.99%, it will be refused. I'll be honest with you. If the child is more than 21 years old, about 99.99% of the times, the application will be refused. Now, if it is refused, you take it to court. And then you provide all the documents that I've just mentioned, plus more, that I can't list everything here. You take it to court. Then you give your evidence. You will be re-examined, you'll be cross-examined and re-examined. And once you are consistent, you can prove to the judge, look, this is the way it is. I have been responsible for all my children's needs or my child's needs till they turn 21 and above. I can assure you that you have a good case to win. You have a good case to win. So that is for adult dependent children who are more than 21 years old. You need to prove relationship. You need to prove dependency. Dependency is what I've just talked about, and there is a lot more. There are case laws that support what is dependency. You don't have to prove for 100 years or 20 years, but you have to prove that without you, the child cannot meet their material and essential material needs. Yes, they cannot meet their material and essential needs. You are the one that provides for them. So that is that. Now let me go to children that are below 21 years. If you have a child, you are an EU national from Germany, Portugal, Spain, Italy, and all the other places, and you have a child that is under 21 years old, that is straightforward. All you need to show is relationship. You do not have to show dependency. You only have to show relationship. You do not have to show dependency. Only relationship, not dependency. So in your case, birth certificate, DNA, weighing card, this will show that the child is your child or the children are your children, and then you can bring them to the UK. DNA, birth certificate, weighing card will establish the relationship. Grandchildren, we have the case of PG and BG. The case of PG and BG says grandchildren are also family members. Sometimes it is easier to bring the grandchildren than to bring your own child, because once your own child is more than 21 years, it becomes difficult for them to prove the dependency. But remember, the grandchildren are almost always certainly below 21 years old. And all you have to do is prove the relationship. And once you can prove the relationship, that's it. You can bring your grandchildren to the UK without any difficulties at all if you are an EU national and you can prove that. We need the EU nationals prove that they are in the UK, they are proved residing in the UK. If they have bank statement, pay slips, they can add all of this to support the application. And I can assure you that if they are under 21 years, they will come. All the ones we have done that are under 21, they've all been successful. All the ones that we've done that are above 21, we've not been successful in all of them, but we went to court and then we have won some of those appeals. We haven't won all because sometimes the person goes to court, the papa na court, and then the court. You have some questions about Nibano. What was the last time you spoke to your child? You can't remember. What was the last time you sent them money? The money transfer receipt is saying a different date. You are also saying a different date. So the judges will say, oh no, if you really look after your child and you are saying the last time you sent money was 2 months ago, meanwhile there is money transfer on the thing which says that you sent money yesterday, it means that you are not being consistent. You are not being truthful to the court. They can base that and refuse the application or dismiss the application, not because the lawyer didn't do a good work, but because you did not speak well in court. If what you say is not consistent with the evidence, the documentary evidence in court, your appeal will be dismissed. And it is not the lawyer's fault. It's because you did not give a consistent evidence in court. And that is what happens. So, and let me say it again, if they are under 21 years, no problems, straight away, proof of relationship, supporting evidence, application will be granted, they'll come to the UK. Above 21 years, do the application, it will be refused, you take it to court, you challenge them, you win the appeal, your child will come to the UK. So generally, EU nationals can still bring their family members. If you marry, I've talked about children. Now, if you marry, if you're an EU national and you marry, can you bring your wife or your husband? The answer is yes. You can still bring your partner. Now, two things. If your partner or if you married before 31st of December 2020, your application will be considered under the EU law. Let me say it again. If you married before 31st of December 2020, that is before the UK left the EU, then your application will still be regarded under the EU law, Appendix EU. But if the date on the marriage certificate is 2021, 2022, 2023, then although you are married to an EU national, your application will be considered under the UK law because the UK left the EU before you married. And therefore, the person may have the EU passport, but the application will be regarded under or be considered under the UK law. If you married, look on the date on the marriage certificate. what is the date of marriage? If it is before 2020, December, EU law. If it is from the 1st of January 2021 and beyond, UK law. So these are the provisions that we still have for EU nationals and their family members. Excellent. A lot of EU nationals are still not aware that they can bring their family members. I did it for a gentleman, two gentlemen and their sister the other day. They are about 35 years old. The oldest is about 37, followed by 35, and their sister is about 32 or so. They all got it. They were refused. We took it to court, successful. They are now in the UK. So this is what it is. EU nationals, you can still bring your family to the UK, even though the UK is no longer part of the EU. So DJ, this is what I want the listeners to be aware of, so that if you have children outside the UK and you want to bring them, you are more than welcome to bring them to the UK, provided you follow the procedures that you have to comply with. DJ, any questions?
Thank you. Champion lawyer wisdom, Akaho Wiseman solicitors. Obinfo, champion man. Anyway, let's go to I can see from the comment sections if we have some questions for you. So you can send your question at the comment sections. If you have your questions, you can just drop them at the comment sections. Everyone's 35 minutes.
Yes.
They be end from 5:30 to 7. Fridays. Every Friday be a lawyer will say 5:30 to 7. And Aisha Germany with me and back. I'll catch them say, oh, you want to with me and back. Thursday say I'm the Schengen for Germany phone. But now they can't UK asem. And the UK no can so no can we mo am got na Europe for no Schengen for na mo got na UK. And no asem so na ye kan na nti ni nyina efrafra. Nti comment section I think say me wo questions 1 or 2 be let's take this one. Me ba mo chawo question afabra enye say ba be pon na obeba na nya me last hour. Start type your questions straight. Ni enko. So lawyer first one enko.
Hello, Richard Sego. I want to know if asylum rules that grant you stay in Scotland and Ireland are different from England. I guess they are the same. Now, the United Kingdom is made up of 4 countries. I say it is NEWS, NEWS, NEWS. N stands for Northern Ireland, E stands for England, W stands for Wales, and the S stands for Scotland. So these are the 4 countries that make the United Kingdom. Okay? And the rules that govern the United Kingdom govern these countries. So Scotland would have the same asylum procedure as the UK, more or less. Ireland, if it is the Republic of Ireland, that is different. But if it's just the Northern Ireland, then it's going to be the same rules as it is. There might be little minor differences here and there, but principally, it's the rules that govern asylum in the United Kingdom that applies. Sandra Abena Donko, I've been at your place before. Thank you for your advice. It has helped me a lot. Thank you too. Thanks for coming. I'm grateful. Can an EU member bring his or her family in the UK and later decide to go back to a EU state he or she comes from to work? Please try bring Mr. Obing Darko for financial investment teachings. that's all right. That's what DJ. So anyway, now if the EU national was in the UK, they've lived here for let's say 5, 6, 7, 8 years or 10 years, and they have their indefinite leave to remain or settled status. Now the only time their leave will be considered as broken is if they are out of the UK for I think 5 years. If they're out of the UK for 5 years. So if the family members are here, and maybe the EU national has been here and they already have their indefinite leave, even if they go back, it is deemed that they have established status here, indefinite leave here. So even if the family members go back, as long as based on the law they don't stay out for more than 5 years, I would advise every year coming go out, come in, go out, they are still regarded as people who are in the UK. But if you go away, completely you cut ties for more than 5 years, you end up losing your indefinite leave status, and therefore it will affect the family members who are here. Also, let me say this way: some EU nationals, they come here, settle here, work, go and come. Sometimes they work as self-employed persons. So even though the person may not be physically here every single day of the year, because of their self-employed business, they go and come. In that case, they are here. The fact that they are not here 24/7, 365 does not mean they are not here. Provided they have a business they are running here as a self-employed person, they still qualify as a person who is resident in the UK. So the bank statements will show that they are receiving funds as a self-employed person. They file their taxes, they do their self-assessment. There is evidence of money going in and out of the account as a self-employed person. Their bank statement shows that it is active, and on that basis, they are able to provide proof that they are still in the UK. Emmanuel G or Guy, can I help pay my brother's school fees in the UK? I would advise that the money should be in your brother's account. It's supposed to be there for 28 days or so in the account before they give them the visa. But once they have arrived in the UK and you have to make the top-up payment, of course, you can pay on your behalf. It's not, we do it, I mean, people do it on their behalf of their family members. So yes, you can do that as well. Sometimes changing the money from Ghana to the UK becomes a lot very onerous. So if you have the money here, you can just pay on their behalf, and maybe you could get them to instruct them to use the cities there for whatever you might want them to do in Ghana for you. Hello, Kojo Ewusi. Please, I am a student, but I want to switch to work visa. What must I do? My dependent was refused visa. Um, if you're a student and you want to switch to work visa, then you need to get an employer who would issue you certificate of sponsorship, COS. And with a certificate of sponsorship, you are then able to switch to become a worker in the health and care sector. A few weeks or so ago, I made you aware, or I made the listeners aware, that the government is trying to stop the government is trying to stop students from switching from the student route to the work route, because they said the universities are losing millions of pounds. People come to school, they don't go to the school, they don't go to the university, and the universities lose those places, and they don't get the funds that they are supposed to get, because they budgeted for maybe 200 students, and only 100 or 120 students come. 80 students don't attend, so they end up losing those funds. So the government is trying to stop students from switching from the student route to the work route until and unless they finish their course before they can switch. So it hasn't taken into effect yet. If you want to do it, I think there is still the chance for you to switch. If your dependent was refused, then they are still dependent on you. If you switch, then you can switch with them. To win EU cases related to 21 years and above dependency would be very compelling. Yes, it is. From the explanation, it takes consistency of strong bond with your dependent in order to triumph. It's all about lawyer. Thank you very much. It's true. It's true. When when the children are above, or the child is above 21 years, it is difficult. It is not easy. It's not a walk through the park, or just easy. They will refuse, but you need to challenge them. Consistency, consistency, consistency. And when you go to court, the evidential evidence you have, the papers you have, the money transfer, the door to door, the tenancy agreement, the documents you have for your house, and your visits, your WhatsApp messages, and everything you show must be consistent with what you will say, or what you say must be consistent with what you have provided in court. If you go and say something else, straight away your case will be dismissed, and you end up losing. Meanwhile, you'd have spent a lot of money appealing, etc., etc., etc. So please take note of that you need to be consistent when you go to court in these cases. Thank you. Rider TV, the award-winning program is on live. Big ups to you, DJ, and thank you, Rider. DJ, big ups to you. You are the man.
I'm more fans. More fire. Lawyer Wisdom Macau. More fire.
Oh, DJ, you are the man. Amazing grace. DJ and lawyer, thank you so much for what you're doing for the community. We appreciate you. We appreciate you more. We really, really appreciate you too for listening and sharing. And we share knowledge amongst ourselves. Thank you so much. We are grateful that you always keep watching. Thank you. Amazing grace. Thank you.
Okay, big one. Be my also WhatsApp.
Okay, I want to move to Europe, but you didn't reply my message on WhatsApp. Okay, can you just send it again? Watching you live from Republic of South Africa. Now, if you want to move to Europe, in what category? We need to know what category you want to move in. Are you coming as a spouse? If you're married, then you can come as a spouse. If you want to come as a student, then you need to get admission to an institution, a university or a college. That will give you the admission, and then they'll issue the CAS letter, confirmation of acceptance letter. You can use that to apply for your visa. So if you want to come as a spouse, the option is there. If you want to come as a student, the option is also there. You have to do the groundwork. If you want to come as a tier 2 worker, then you need to, of course, get an employer who will offer you job, give you COS, certificate of sponsorship, and then you have to apply to come to the UK. But the employer must have a certificate of sponsorship before they can offer you the COS. They must first have the license from the Home Office before they can offer you the COS to apply to come to the UK. So yes, my dear brother, there are options to come to the UK, but you have to fall within one of the categories. Or if you want to come as a visitor, you can apply yourself. You can make sure everything is in place. Visit visas, I always tell my clients, visit visa is 50-50. It's always 50-50. It can go either way. You may win, you may lose. Visit visas 50-50. It is never guaranteed. So if somebody tells you, I'm going to get a visit visa for you, and by all means, I'll get it for you 100%. For me, it is not 100%. It is 50-50. So if you're applying as a visitor, just have it in your mind that it can be refused or it can be successful. If it is successful, you praise God. If it is not successful, you don't get too disappointed because you know it's 50-50. Hello, Enoch Datsun. Is that Osofo? Hello, my wife is teacher with QTS, but I want her to come to the UK via care route. Hope is advisable. Yes, of course. If she's a teacher. Now, with the care route, you don't have to be a carer to come to the UK to work in the care sector. What happens is when you come, they train you. The employer trains you. So therefore, if she's a teacher, teachers are versatile. Teachers can move in all directions. Teachers are the best because I was once a teacher. So you can move in all the directions. So DJ, I was in a training college. I think last week somebody told you I was his social science teacher.
Social studies teacher.
Social studies teacher, yes. So I was a teacher in a JSS in Medina, in fact, Medina Islamic JSS. That is where I was. And then I was also a teacher in one of the Dodowa district areas.
That's why I say you are being full.
Oh, I beg.
Now you are a lawyer.
I beg. So if your wife, don't go there. I beg. So if your wife wants to come as a care worker, provided she can get the certificate of sponsorship, please, she can come and she can train and she can work as a carer. No problems with that at all. And Mr. Frempy, I am an EU national. Can my partner be removed out of the UK after his BRP has expired? His settlement application hasn't been granted, and that was 2 years ago. Do you have any info on what to do? this is something we can talk about. Actually, I need to ask a lot more questions. If you're an EU national, when did you marry? Did you marry before the UK left the EU? I need to know. Wait, did they invite you for interview? I need to know. When you went for the interview, did you give consistent information? Did you say exactly what he said? Did you say what you said? Was it consistent? Were there discrepancies in your statements? Did they refuse the application because of the discrepancies? Did you take it to court? In court, what was the outcome of the decision? I need to know all of this. And then I would advise if he can make another application or if he should seek for another option. So, yes, I can advise, but I need to see the evidence that you have before I can advise. I can't advise in vacuum. I need to see what the history is before I can say go left, go right, or stay put. So if you can send me some more information, I'll be more than happy to assist you. Thank you.
Nice one. Lawyer Wisdom Akao Wiseman Solicitors. More questions na akabe 20 minutes na appointi. So questions bi obese obisa na obetimi ebisa na nsa na appoint. So bibi ni o na mema. But lawyer me bisa we say EU ni na obi of Italy na or apply for dual citizenship etimi ejuma o UK. But obetimi age Italy there na waji UK so there at the same time it's possible.
Possible, sir. Some countries allow dual nationality. Germany, I know, does not permit dual citizenship, but I think Italy does. I think Portugal does. I think some countries do. So first of all, just go online and Google to find out if your country of nationality allows dual nationality. If they do, then of course you can apply for that, and then you can still rely on your EU settlement, your EU status in the UK. So even if the person is a British citizen and they still have EU passport, their children can still rely on the EU citizenship, not the British citizenship, and still bring their family members to the UK. So yes, it is 100% possible to do that.
Okay, let's go.
Okay, now I want to look at. Oh, there's a question. I'm British. Can I bring my niece to the UK, and what are my options? Your niece to the UK, possibly as maybe a student, a care worker, or a spouse in a different category if they are married. But on you yourself as your niece, that can be possible, but the possibility is there, but the probability is very, very small. You will need to prove that there is a reason why they cannot remain in Ghana, maybe medical grounds. There's an exceptional, compassionate circumstance why they cannot remain in Ghana. Maybe serious medical conditions, and there is nobody in Ghana to look after them, even if you send money. On that basis, you can apply, but those applications are not guaranteed at all. They are very expensive, but it is not guaranteed at all. So if your niece wants to come and they are in a relationship here, they get married, they can come as a partner. Or if they are coming as a care worker, that option is there. Or if they are coming as a student, of course, that option is there as well. Thank you. Ohene Ajekum, hello, sir. Please, which type of application can you do after being banned from 10 years for 10 years from the UK? Please keep me here. Please help. You can apply as a spouse. You can apply as a spouse if there is a genuine relationship with a spouse in the UK. Genuine relationship, and the emphasis is on genuine relationship. I would advise that you wait for, in fact, I'd like to see the refusal decisions before I say, is it a 10-year ban subject to paragraph 320, which of the sections? We have 327A, 327B. Some of the decisions are mandatory. You will be banned. Some are optional, discretionary. So I need to see exactly under which paragraph or under which sub-paragraph or sub-clause of the paragraph 320 on which the person was banned before I can say yes or no. But it is possible to apply even with the ban or possibly after the ban. Can you do a proxy marriage in the UK and based on it to legalize your status in the UK? Of course, maybe I have to talk about the proxy marriage next time. Ghanaian customary marriage. What can you do? Ghanaian customary marriage. One called Ghana. Ebusianfo ewa Ghana. One called who UK ha. The woman is in the UK. The man is in the UK. You haven't been to Ghana. Is it possible to do a proxy marriage? Yes, it is possible. In Ghana, we have three types of marriages. At least that is what we know. We have the Muslims. They have their type of marriage. We have the ordinance. The ordinance is the one you go to the court, don't do, and then you go and sign the certificate. Mean with ordinance, the man and the woman will have to be physically present in the at the registry. So people bring me the long certificate with some green line across it. I ask them, were you in Ghana for the marriage? They said, no, I wasn't in Ghana. Then I tell them straight away, you cannot use this marriage certificate because the ordinance certificate is you have to be physically present at the ceremony at the registry. So if you were not there, you cannot use that certificate. The customary one is the third one. The customary one, it can be done by proxy, although technically it is not proxy. Why? Ghanaian cultural marriage is between two families. You can love the woman as much as you want to, but if the family say you are not going to marry her, you cannot marry her. So the man's family can go to the woman's family, and if the woman's family says, no, we don't want to marry into your family, or you don't want your family to marry into our family, there is nothing you can do. So the family marriage is actually between, the custom marriage is actually between two families, the man's family and the woman's family. As long as the families in Ghana can represent you, you do not have to be in Ghana. As long as the families can represent you, they can contract the marriage ceremony on your behalf. They can do it on your behalf. And that is why we say proxy. Technically, it is not proxy because it's actually between the families, and the families are already there. So it's not proxy, but for lack of a better, we call it proxy because the representatives, the applicants, the husband and the wife are not there. So we say proxy. They are being represented in Ghana to do the marriage. So yes, it can be done. And then a certificate will be sent to you. They'll take the pictures, beautiful pictures, very beautiful pictures. The woman's family, the woman will go with the portmanteau, the beer bottles, the Fanta, they package everything nicely, the envelopes, the women who dress up nicely, they carry the baskets and the gift. Or you take pictures of every stage of this ceremony. When they are doing the exchanges, they take pictures. You bring all of this to support the fact that, yes, even though we were not in Ghana, the families represented us and did this on our behalf. After that, the representatives will swear the statutory declaration that I, Apenyu Kojo Menu, represented Kojo Ansa, and I, Madam Antia, I represented Monica Afo. Based on this, we swear to say that we did it on their behalf. We take it to the judicial service, they put their letter on top. We take it to the Ministry of Foreign Affairs, they put their letter on top. The marriage certificate is registered with AMA, KMA, TMA, HMA, all of them. You can bring it to support your application, and it is 100% acceptable in the UK. By virtue of the case of CB Brazil, the case of CB Brazil says if the marriage is acceptable in the country in which it is conducted, it is acceptable in the UK as well. And as long as the custom marriage is accepted in Ghana, under the case of CB Brazil, it is also accepted in the UK. The case laws, the case of NA Ghana, the case of Yaote and Kwe, the case of Amwakung, all these cases support the fact that customary marriages are acceptable in the UK. Thank you. Good, Nick. Okay, let me just mention the good. The other one I'm struggling. So he says, I am a non-EU citizen, but I am married to an EU citizen that has settled status. Can I apply for my daughter who has different father? If your daughter has a different father, I don't understand. If you're a man How does your daughter have a different father? Unless let's put it this way, if there is DNA which shows that you are the father of the child, maybe at the time the child was born, the mother believed that somebody else was the father, but a DNA now proves that you are the father. Once the DNA report is there, and you write to the or you go to the registry for them to change the child's your name, put your name in the margin of the birth certificate, then the child becomes your child, obviously by DNA. Then you can apply for the EU settlement scheme, 5 years or indefinite for the child as well. Echo Edu, hello. Can a British citizen bring his child older than 20 to the UK? What are the options? No. If the child is gone past 18 years, it becomes almost impossible for a British citizen to bring their child. EU nationals have up to 21 years and above. British citizens 18 years and below. In fact, below 18 years. Once they go past 20 years, once they go past 18 years, it becomes almost impossible for you to bring them as your dependents to the UK. But of course, they can come in other categories, let's say students, etc., etc. Mr. Jekum, I am refusing your application under paragraph 972 of part 9 of the immigration rules. Yes, that is paragraph 320.972. The 972s, we have the mandatory refusal, and there are some which are discretionary. I will need to go back to it. Call me after the program. I will take it 972, paragraph 320.97.2. We'll look at it point by point by point to see if that is one of the mandatory compulsory bans for 10 years, or we can find some word there which makes it discretionary where you can slip through the net. If not, then you may have to comply. But please call after the program immediately. Within the next 15 minutes, I'll be available. After that, I'm moving into another program altogether. Thanks, DJ and lawyer. Can I please have an appointment with lawyer to discuss into detail my issues? Yes, of course. You can have appointments. The office number is 0208 0208 0165 384. My main is a lotto number 0208 0165 38 and single 4. 0208 0165 38 4. 0208 0165 384. That is the office number. Call the office Monday from 9:30 to 6. We are here. You can also come book appointment. My mobile number is on the screen 079 31 411 042. 07931 411 042. I'm more than happy to guide, to assist, and help you navigate the routes. Kasim, says Mr. Kasim again. Please, I am an indefinite leave to remain holder and about to expire. What document do I need to get things done? I am shareholder, so please consider me. Yeah. You are a shareholder, yes. Lukman Kasim, hi, it's a long time. You're a shareholder indeed. Now, all my clients are shareholders. All of them have a share in the business, so thank you. Now, if it is you have indefinite leave. If you have indefinite leave, you have indefinite leave. Now, if it's about the card is about to expire, it doesn't mean your leave has expired. Indefinite leave means indefinite leave. Now, they are putting all the biometric resident cards and permits on 31st of December 2024. 31st December 2024. All the cards, biometric card and biometric permits are all ending 31st December 2024. Now, the fact that the card has ended or the card is ending doesn't mean that your visa or your leave is ending. Your visa can extend forever. I would advise you, if you can write the Life in the UK test and the B1, why don't you go for your British citizenship rather than going for another card and the date will still be the same? So please write the Life in the UK test and do the B1. If you are struggling, come to me. I will help you. I will guide you. I will direct you. There is an app that if you go through it over and over, I can assure you, you will pass the Life in the UK one touch. You will pass it one touch. There's an app where you have to go through the questions. You go over and over. There are a lot of questions there, but if you practice it over and over for some time, it's the same as the questions in the books, the Life in the UK book that you buy. And when you go through the book plus the app and the questions online, you will pass, go for your citizenship rather than wasting money for another indefinite leave, which the card will still end on 31st of December 2024. Anyway, somebody came to me the other day. She didn't even know she had indefinite. She was coming to me, an elderly Nigerian woman. She was saying, "Lawyer, can you apply for me? Because I don't know what to do." And I asked her, "Have you made the application before?" She said, "Yes." "Can I see the letter that you were given?" She showed it to me. She already has indefinite leave to remain. She didn't know. So I just told the mom, "Ma, you have indefinite. I don't have to take your money for something that you already have. I would rather advise you to go and do the Life in the UK test plus the B1, and then you can come and I'll do your British citizenship for you." She was so grateful. Otherwise, somebody else would have taken her money and do the same thing for her, which is actually pointless. We don't do that. So I just directed her, please do the Life in the UK test, do the B1, come to us, we'll get you your British citizenship. Mr. Kubi, can you bring your partner from Ghana without writing the English test? Now, if your partner is more than 65 years old, yes, no English test. If your partner has a first degree, yes, no English test. If your partner has serious medical reasons why they cannot write, and the Home Office accepts that, then yes, no English test. But these are the exemptions. Life in the, what do you call it? Degree, but it has to be certified by ACTIS. Degree, certified by ACTIS, that is one. Two, if they have, they are more than 65 years old, of course, they can also come without writing the life in the, without the English language test, or if there's a serious medical condition, and because of that they cannot write the English test, certified by a medical doctor, then possibly that can also be a reason why they can apply. I did it for a lady. She's an Ivorian. She could not write the English test, and that time there was a bit of confusion in Ivory Coast. So I did the application and I told the Home Office that, look, give it to her because she is not in her comfort zone. She's not in Ivory Coast. She had moved to Ghana. Give it to her, and when she comes, it will be mandatory for her to write before she extends her visa. And they gave it to her. But these are very exceptional cases. Thank you. Can an EU citizen bring a sister to the UK? Unfortunately, from the 31st of December 2020, it is no longer possible for EU nationals to bring their extended family members, sisters, brothers, uncles, nieces, aunties, all of them, they've been removed from the EU settlement scheme application. So unfortunately, they cannot bring the sister to the UK. Mr. Ajeku, my elder brother is coming to the UK as a care worker. Is it advisable to travel to the UK with his 4 daughters without the wife? That is purely an individual's decision. Purely an individual's decision. How, if he can manage the 4 daughters and work at the same time, that is for him to decide. The point is, how old are the daughters? Are they able to go to school by themselves? Are they able to come back by themselves? Are they able to do their own cooking, their own washing? Are they able to do all these things themselves? If not, it means that should the children come, he has to apportion his time between work and looking after the children, dropping them in school, picking them from school, doing all the rounds. It's for him to decide if he can juggle the 2 responsibilities. So that is what I can say to that. I can't give a yes or no answer to this particular question.
Thank you so much, Lawyer Wisdom Akao. Time is up, guys. Thank you so much for watching SBTV Africa. Lawyer, I mean, you can put your office address and all that. God willing, next week we'll meet again. 5:30 to 7.
Thank you.
GMT.
Wiseman Solicitors, I'm Wisdom. Wiseman Solicitors, number 8 to 9, The Print House, 18 to 22, Ashwin Street, Dalston Junction, London, E8 3DL. E8 3DL. Telephone numbers 0208 0165 384. 0208 0165 384. Telephone number, mobile number is 079 31411042. Those are my numbers. We have Nana Amwa, Nana Ohene Amwa. His number, I think, put it out the other day. Let me do it again. Nana Amwa's number is, give me a minute. Nana Amwa. His number is 077 3757 2905. 077 3757 2905. That is Lawyer Nana Amwa. And then we have Lawyer Francis Bosom Pim. His number is 079 4677 2439. 079 4677 2439. That is for Lawyer Francis Bosom Pim. We are directly behind the McDonald's at Dalston Junction, very close to the Dalston Market. Very, very close to the Dalston Market, directly behind the McDonald's. Should you need our support, our assistance, our directions, our guidance, we are more than happy to assist you. Call the numbers during the week, call the numbers, and we are more than happy to assist you. DJ, thank you so much. I'm grateful.
Thank you. Thank you, Lawyer Wisdom Akao.
I'm grateful. Thank you. Thank you.
You better not say Lawyer Wisdom Akao say every Fridays biano or the teachings we bring very important and very educative. And you can say na mon share no so share ma onua bi. O dey say o dey nya UK na ukokra na share ma obi ebebo no. Until like page na share na subscribe and na be eba live or be notification. Video send there the ba and Ghana for some more quantum ni din komo. Mo mo share na nyina me da ma say time aso. Mami Akua me da ma say mami mam shout out Zakara Misani Henrietta Asante. Good meaning. I don't know. It's a good meaning. The one trying to lawyer according to me and bet Kwesi Grant Quartin. Thank you so much. Nana Masika Rex for Dankwa. Thank you so much. Love for you. Thank you. Truth Media GA. Thank you so much. Isa Mudu. Thank you so much. Kobe Isaac. Big ups. Lukman Kasim. Big ups. Frimpy, big ups. Junior Agogo, thank you so much. Eko Edu, thank you so much. Nana Ajua Pokia Chumuwa, thank you so much for watching. Abeshe SBTV Africa Damase. Enoch Aqua Daxon, thank you. Emmanuel J, thank you. Amazing Grace Comfort, thank you so much. USA SBTV Africa fan. Kobe, thank you so much. Robert Granting, thank you so much. Kojo Ewusi, thank you so much. Emmanuel G, thank you so much. Okay, Kwesi Bosumpim, thank you so much. Lawyer contact in the other screen. Richard Sego, thank you so much. Sandra Abina Donko, thank you so much. Charles Ansa, Medase Big Ups, Eric Owusu, Kwesi Amponsa. Daniel Quesin, Popcan, thank you so much. Rider TV, thank you so much. Guys, thank you so much for watching. Madam Ansamo share SBTV Africa. Videos in the baby a droppy video class is here and Sana Meba live. Me another video, but hot interview party. Daily also worldwide, the only the internet. So I me showing this my numbers the good screen so WhatsApp me and answer send me voice notes or share videos now subscribe now follow here. I'll be home in numbers. My numbers so Lawyer Wisdom account me that say. Madam Production Team as DJ Click Sharon and Atina. Yami Aduma. Video soon the bar neighbor. enyumre we echina weekend we Monday Tuesday every day videos they come 4 5 5 so a very educative program one sha abuan kofu bebre media behind the scene omuka che me thank you so mama kodu anya me do am ho kire me o ma me link sa bebre but connection there mama friend me say we want travel I need to do I no get you see say me I dey talk to immigration lawyers I need to do connection so me they don't can ask me uni agent omo bisa me dey be I no get me kan omo ntiase I no get me dem say Ushabo Chroma can say 2 no ma just 2 so 2 makra